As many of us know, the Supreme Court recently ruled that affirmative action in college admissions is unconstitutional. Over the past 3 weeks, there has been a lot of misinformation about what the law says with regard to this issue, and frankly, it has been driving me crazy. So I have combed through the 14th Amendment, the Civil Rights Act, as well as the court's previous rulings on affirmative action. Today, I'm going to be explaining what the law really says, and also I'm going to address some non-legal moral arguments about this issue. I'm Julie Hartman, and this is Timeless. Hey everyone, welcome to Timeless. I hope that you're having a great week. Just a reminder to hit the subscribe button down below so that you can stay notified every time I post a Julie Noted news video or a Timeless episode. And also be sure to follow me on Instagram and Twitter at Julie R. Hartman. I've done Islam 101 episodes, Islam 101 Part 2 episodes, Machiavelli 101 episodes. Today we are doing What the Heck Happened with Affirmative Action 101 episode. As I said in the introduction, there's been so much misinformation over the past few weeks. And what's interesting is that I have noticed a lot of the times that people talk about affirmative action, whether they are for or against it, whether it's on TV, pundits talking about the issue, or in the opinion sections of major newspapers, people tend not to talk about what the law says. They tend to use evidence of certain outcomes or even invoke their own opinions about the matter. Of course, people are allowed to use those two lines of arguments to argue either for or against affirmative action. But we must not forget that this is a matter of law, first and foremost. So today we will be spending the majority of the episode going through the law in an easy, understandable way. As I said, I've combed through it, understanding the precedents. And then I will turn to 3 counter arguments, non-legal moral arguments that people have against the court's ruling, that is for affirmative action in college admissions. And we'll be deconstructing those. Let's start, though, with the first case that dealt with affirmative action that the court ruled on. This was the Regents of the University of California versus Bakke. This was in 1978. So with each of these, I'm going to go through what was at stake here and then how the court ruled. This case, the Bakke case, was originated by a man named Alan Bakke. He was a white veteran with a solid academic record, and he applied twice and was rejected twice from the University of California Davis Medical School. Now, UC Davis Medical School at the time had a policy which said that it would reserve 16 out of 100 spots in each class for racial minorities. And they said that their stated purpose for doing this was to rectify the wrongs of past discrimination. Now, Alan Bakke's MCAT scores and GPA exceeded those of any of the minority applicants that were admitted in the 2 years that Mr. Bakke was rejected from the medical school. So thus, he filed a suit, which made its way all the way up to the Supreme Court, and he alleged that the university had discriminated against him solely on the basis of race. He qualified to get into the class, but he was rejected, he says, because of those 16 out of 100 spots reserved for non-white applicants. Mr. Bakke said that this violated his right to equal protection under the 14th Amendment, which is one of the amendments in our Bill of Rights. And the 14th Amendment says, quote, "Nor shall any state deny to any person within its jurisdiction equal protection under the law." Now, to pause for a moment, you may be wondering, wait a minute, the 14th Amendment says, "Nor shall any state deny to any person within its jurisdiction the equal protection of the laws." It doesn't say, "Nor shall any university deny to any person equal protection of the laws." How does the 14th Amendment then apply to UC Davis? UC Davis isn't a state, it's a university. The answer is that UC Davis is a public university, which means that it was set up and run by, and crucially funded by, the California state government. So in our legal system, there is our legal system considers entities that are run by the government to be government institutions, and thus they are beholden to the Bill of Rights. This may seem like just kind of a minute thing to understand, but this will come in really handy in just a few minutes when I talk to you about the Harvard and UNC cases that were just ruled on a few weeks ago, because Harvard, where affirmative action was just struck down by the Supreme Court, is a private university. So it is not beholden to the Bill of Rights like a public university like the University of California, Davis is. So we will see in just a few minutes that people suing Harvard for its affirmative action policies did not cite a violation of the 14th Amendment. They cited a violation of the Civil Rights Act, but again, we're going to get to that in just a moment. Back to the Bakke case. The Supreme Court technically sided with Alan Bakke, agreeing with him that the university had discriminated against him on the basis of race. But, and this is a big but, oh, Sean will laugh at that one. The Supreme Court also kind of sided with UC Davis. The Supreme Court ruled that the strict use of a quota was unconstitutional, the quota meaning 16 out of the 100 spots in the medical school class being reserved to minorities. They said it's unconstitutional because it is explicitly unequal. This makes sense because minority applicants were eligible for 100 spots in the class, while white applicants were only eligible for 84 spots in the class. So just as it would be unequal for the University of California, Davis to say that 16 spots out of 100 spots cannot be held by a certain group, it is also unequal for the University of California, Davis to say that 16 spots out of 100 can only be held by a certain group. That is constitutionally equivalent. So far, makes sense. But the court also ruled in, as I said, kind of in favor of UC Davis. They said that although UC Davis is not allowed to use quotas or take numbers into account, they are allowed to consider the race of an applicant as long as A, it is just one factor among many that they are considering when evaluating the applicant, and B, if their reason is to promote student body diversity. You may remember that I just said that the University of California, Davis said that its reason for reserving 16 spots out of 100 for minority applicants was to rectify the wrongs of past discrimination. The court said that cannot be your reason, because redressing the wrongs of past discrimination applies only to one group. But taking race into account for the educational benefits of diversity, that applies to everyone, minority and non-minority students. So thus, that is more equal than a reason that just applies to one specific group. So in other words, what the court ruled, and this was the precedent established in this Bakke case in 1978 and continued all the way up until 3 weeks ago in 2023, that position was that the court allowed affirmative action, but just in different packaging. You can take race into account, the court said, but you cannot use numbers. And you can take race into account as long as your reason is to promote student body diversity, which is an educational benefit, and not redressing the wrongs of past discrimination. So there are 3 more major cases from 1978 to 2023 that I'm going to talk about. We're going to go through them much quicker than we just did that Bakke case, because that Bakke case is really important to just understand the foundation. But these next 3 cases that I'll go through show that the court was consistent in upholding their precedent on affirmative action. The next case of significance was Gratz versus Bollinger in 2003. Jennifer Gratz, who is a white young woman, was rejected from the University of Michigan undergrad. And she argued that she was discriminated against because the University of Michigan, for their undergraduate program, had a policy where they evaluated candidates based on a point system. And they automatically awarded an additional 20 points to someone who was a member of an unrepresented minority. So Ms. Gratz argued, that's kind of a quota system. You are taking numbers into account, adding these points automatically. That gives advantage to a certain race. That is unconstitutional. And the Supreme Court agreed with her. They ruled, going back to the Bakke precedent, that Ms. Gratz was right, that quotas are unconstitutional under the Equal Protection Clause of the 14th Amendment, but they said that the University of Michigan could still have a diversity program as long as they took race into account as only one factor among many, and as long as they said the reason for that was student body diversity and not redressing the wrongs of past discrimination. Okay, they were consistent in 2003. The second court case after Bakke was Grutter versus Bollinger, also in 2003. This also concerned the University of Michigan, but it actually pertained to the law school as opposed to the undergraduate program. And the court followed the Bakke precedent. They upheld the use of a diversity plan in the law school that wasn't tied to a quota, that considered race as one factor among many, and cited the reason as diversity and not rectifying the wrongs of past discrimination. I'm really repeating and trying to inculcate it because it's so important to understand these details to get the way that the court reversed its precedent in 2023. What's important about this case, the Grutter case, is a famous line that Justice Sandra Day O'Connor wrote in her opinion on that case. She said, quote, "We expect that 25 years from now," we meaning the Supreme Court, "we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." That's really important. Now, this case was in 2003. She is saying 25 years from now, so technically that would mean in 2028. But there wasn't a hard rule that affirmative action could only be overturned starting in 2028. It was reflecting that the justices thought that in a certain amount of time, affirmative action wouldn't be necessary. In other words, this is not just something that they intended in their rulings to continue on forever. And then the third case I'll tell you, which upholded, the Bakke precedent, was Fisher versus the University of Texas. This was actually ruled on twice. First in 2000, what did I say? Oh, I said upholded. Oopsies. Well, that's why you have a Shanzi listening and correcting. Good catch. What did I say the other day that was so funny? I was talking about, Talon. I have a show where I analyzed the symbols on the $1 bill, which, by the way, is a total interesting episode. You should all go and watch it. There are all these cool national symbols or even spiders on the $1 bill. And I was talking about the eagle, which is the national symbol of the United States. And it's holding arrows and olive branches in its talons, I said, but apparently it's talon. I blame my math teacher in high school. He was Dr. Talone, who I adore, actually. So shame on him for putting that in my mind and making me misspeak. Yes, upholded is not the right verb, upheld. Anyway, let's go on. Fisher versus University of Texas. This was decided on in 2012 and also again in 2016. Basically, the University of Texas agreed in its undergraduate program to automatically admit all high school seniors who ranked in the top 10% of their graduating class. But then, once they admitted those individuals, the leftover applicants could be considered by their race. They could take race into account when evaluating those applicants. Abigail Fisher, a white woman who was rejected from the University of Texas, you notice a pattern here, filed a suit, said that the University of Texas had discriminated against her, and the court said, no, they haven't, according to our precedent. They are taking race as just one factor among many. They are allowed to do that. Specifically, the court said the use of race by the University of Texas was contextual and didn't operate in a quota system. Okay? So now we understand what the position of the Supreme Court has been for the past 45 years. Here are a few problems that arose in the wake of that, and that were really big problems that led to the reversal of the precedent that the Supreme Court recently made. One of the issues was that It is difficult for a university to take race into account without using a numbers system. They're not allowed to use quotas or numbers, but really what was discovered is that diversity plans are kind of quota systems in disguise. How can you have an eye towards considering the race of an applicant without in some way also having an eye towards the numbers in your class? So really, people were kind of clandestinely or in disguise practicing a quota system, which is unconstitutional. And there was evidence of this because if you look at some major universities, for instance, Harvard, who was one of the universities that was sued, they every single year have a pretty consistent number of African American students they take, of Asian American students they take, of Latino students they take. And when you see year after year, certain numbers of the class being pretty consistent, well, that's evidence that Harvard was looking at numbers when the court was saying that they were not allowed to. So that was one of the issues. Another issue, and this was also especially relevant to the Harvard case, was that some racial minorities, namely Asian Americans, were actually being discriminated against under affirmative action in favor of white applicants or in favor of other racial minorities. To look at the statistics, pertaining to Asian American applicants, Asian Americans on average have to score 140 points higher on the SAT than white students, 320 points higher than Hispanic students, and 450 points higher than African American students in order to be admitted to the same university. So what was happening was, frankly, Asian Americans were doing so well that despite being members of a racial minority, they weren't being admitted. And then the final issue was one that many originalists were that is, those who interpret the Constitution as is by looking plainly at the text and not approaching the Constitution with a living Constitution approach, which says that you can kind of read implications or things into the Constitution. A lot of originalists said, wait a minute, the Constitution is either colorblind and equally applied to everyone, or it isn't. Plain and simple. If you look back 60 years ago, most of America wanted the Constitution to be colorblind. For instance, with the issue of certain private and public accommodations being segregated. We wanted to live in a colorblind society which says no matter what color you are allowed to go to the same public accommodations and private businesses or institutions as people who are not of your color. So 60 years ago, these originalists say, we wanted a colorblind Constitution, but now 60 years later, when it comes to affirmative action, we don't want a colorblind Constitution. We want race to be considered in matters of college admissions. So which one is it? It's either colorblind or it's not. And the great thing they argue about not considering race is that it doesn't allow for any kind of discrimination. Some could argue it allows for other things, maybe unequal outcomes, but you know if race is not looked at in any case, there is no discrimination. Before we go on to the Harvard and UNC cases that were just ruled 3 weeks ago this year in 2023, I want to tell you about MyPillow. Now, nothing keeps me up at night more than people making false legal arguments about affirmative action, but I have to say I would probably be up at night already because for my whole life, I have suffered from insomnia. And I know, as corny as it sounds, how important it is to have a good pillow that you are sleeping on. And I have found that in MyPillow. I bought them just about 6 months ago, and it has changed my sleep. They are so soft and comfortable. Using the promo code Hartman, you can get a queen size MyPillow for $19.98. A regular price for that pillow is $69.98 and just $10 more for a king size. So if you're using the promo code Hartman, you are getting a good deal. You can go to mypillow.com and click on the radio and podcast square. Use the promo code Hartman to get your queen size MyPillow for $19.98. MyPillow also sells many other great products that I use, including the extremely comfortable My Slippers. Ask anyone at this office who I work with. They know that every single day, because I don't want to walk in heels, I wear my MyPillow slippers because they are so comfortable. The people at the front of this building who are in security probably think I am deranged because I walk in with a full face of makeup and really cute outfits, but then wearing MyPillow slippers, and the outfit doesn't quite match. But again, they are so comfortable that I want to wear them as much as I can. You can call 1-800-566-6745, 1-800-566-6745, or go to mypillow.com. Use the promo code Hartman to get big discounts on all MyPillow products. Okay, so now let's go on to the present day, 2023. The Supreme Court has ruled against affirmative action, overturning that 45-year precedent. So what happened? Well, the Students for Fair Admissions, which is a group of students who are for fair admissions, sued the University of North Carolina and also sued the president and fellows of Harvard College, alleging that their affirmative action policies discriminated against Asian American students in favor of white students and other students who were members of an unrepresented minority, but not being Asian American. So why were they suing both UNC and Harvard? Well, UNC is a public university and it is beholden to a different set of laws than Harvard is as a private university. Before we get to that, I'm just going to read to you some of what the Students for Fair Admissions alleged and some of the statistics that they cited. They sued Harvard College over its admissions process, alleging that it violates the Civil Rights Act of 1964 by discriminating against Asian Americans, okay? And these are the stats, and I have to say they're pretty damning. If you look at Harvard College, class of 2014 all the way to the class of 2019, so that's 5 years. Among those who were in the top 10% of applicants based on grades and test scores, Asian American applicants outnumbered white applicants by more than 45%. But they were not admitted according to those outsized scores. If they were treated as white applicants, these are the stats that the Students for Fair Admissions cite, then the typical Asian American applicant would see their average admissions rate rise by 19%. So there's a lot of evidence that a lot more of Harvard would be Asian if Harvard did not consider race and only evaluated people based on their test scores and on their merit. I have to say, because I am a recent graduate of Harvard, every time I met an Asian American who was at my college, I thought, boy, you must be not just smart, but really, really smart, because it's just true. You look at those stats, it's absolutely true. So if you're an Asian American getting into Harvard, you must be a bleeping genius, okay? So as mentioned, the Students for Fair Admissions sued Harvard College not under the 14th Amendment, but under the Civil Rights Act of 1964. This is because Harvard is a private university, and unlike the University of North Carolina or the University of California, Davis, private institutions then can do a lot more than public institutions can because they're not beholden to these government rules. But that changed in 1964 with the passage of the Civil Rights Act. The Civil Rights Act desegregated both public accommodations and this is crucial, and private businesses. Now, how were they allowed to do that? Okay, public accommodations are funded by taxpayer money. They are open to the public. That makes sense. But how did the government, under the Civil Rights Act, have the authority to intervene in private businesses? The answer is that there is a line in the Constitution called the Commerce Clause, which gives governments, or our government, the right to regulate interstate commerce. And so what they argued in the Civil Rights Act of 1964 was that because the government is allowed to regulate interstate commerce, then they're allowed to regulate, i.e. desegregate, private businesses, because a lot of private businesses deal with interstate commerce. They have customers that come from out of state. If you look at a coffee shop, they may get their coffee beans from Idaho, and they may get their cups from Florida. So basically every private institution does interstate commerce. That was the way that private businesses were mandated to desegregate. Fast forward to 2023, the same law, the Civil Rights Act, that was used to desegregate private businesses is now being used to overturn affirmative action in private businesses. That is what is giving the court the authority to tell Harvard, a private institution, that it cannot judge applicants based on race, because the Civil Rights Act gives the government to intervene in the business dealings of private institutions, because private institutions deal with interstate commerce, and according to the Constitution, the government can regulate interstate commerce. Harvard does interstate commerce. Why? They get a lot of their students from out of state. The dining hall workers or their professors or other people that work for Harvard come from out of state. The food that they serve to students probably comes from out of state. I don't really know where the heck it comes from. I ate that food all the time. It was awful. God knows where that food comes from. The chairs that students sit on come from out of state. So again, isn't that interesting that people, 60 years ago were using one law, the Civil Rights Act, to desegregate, and now the same law is being used to overturn affirmative action. Just really, really interesting how history works, but it's consistent because it's colorblind. It affirms that the Constitution is colorblind. Desegregating affirms that the Constitution is colorblind because you can let anyone into your business. But also overturning affirmative action is colorblind because it means that no matter who you are, we will not give certain preferences to X group over Y group. We will judge you based on your test scores and your grades. So that is what happened in the Harvard case, and then in the UNC case, they overturned affirmative action by saying that it was a violation of the Equal Protection Clause of the 14th Amendment, and it's not equal to give some students a preference over others. Now, what's important too is that Justice Roberts, in writing the majority opinion for the court, said, quote, "Nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race has affected his or her life, whether it be through discrimination, inspiration, or otherwise. Race-blind admissions are not required." So some say that that sentence or two by Justice Roberts also kind of in disguise allows affirmative action to go on. Though, of course, I don't know if it seems that way. I mean, students can write about anything that has affected their life. And part of what students are judged on is their character and how they may have overcome certain extenuating circumstances that have befell them. So, of course, it seems reasonable that a student would be allowed to write about how race has affected his or her life, just as a student would be allowed to write about how a summer job or a parent dying affected his or her life. Now that we have dealt with the law, which really I think very clearly says it does not allow affirmative action, let's go on to some of the moral arguments or evidence-based, non-legal arguments that have been used to criticize the court's ruling, that are used to say that affirmative action should be allowed in college admissions. But again, the law very clearly does not allow affirmative action. If we are all equal under the law, we ought to all be considered equally under the law when we are being evaluated in our applications to college. Okay, but there are three non-legal arguments that I'm going to go through. The first is the racism argument, that it is racist to overturn affirmative action, and the people who are doing this are motivated by white supremacy. I hate to even include that as a counter-argument, but it's being used a lot today. The second counter-argument is that affirmative action is the only mechanism that can balance us out, that can rectify the wrongs of past discrimination. And then the third argument is that without affirmative action, minority students will not go to college, okay? Let's start with number one, the racism argument. Let's listen to a clip from The View where they are invoking the tired argument of white supremacy. Clip one.
Edward Blum and Abigail Fisher. Yes.
You two have been trying to get rid of affirmative action. Why do we scare you?
Who are they?
I don't know. Well,
Why do we scare you?
The other thing I would say about this is that it plays into what they're talking on the right about post-racial society that we're living in, you know? Because we elected a black president, they think that racism is over. It's not. And that's what bothers me about this rolling back. And also what bothers me also is that what's next? Gay marriage? I mean, they want to get rid of abortion rights, which they practically have done.
I don't really understand what Miss Joy on The View is saying there, that there's some conspiracy to oppress all kinds of minorities. I guess that's why she's bringing up gay marriage and abortion. I mean, obviously it is ridiculous. You know, even our own president has given credence to these arguments. President Biden said a few months ago in his commencement address to Howard University that white supremacy is the biggest problem facing the United States. And in the wake of this ruling by the Supreme Court, which overturned affirmative action, President Biden said, quote, "This is not a normal court," which is insinuating that there is some kind of sinister, bigoted agenda, which is absolutely ridiculous. I'll say this, and then we will move on to the other arguments. We shouldn't even give this one any more time because it's so absurd. I really look forward to the day when people can argue by not defaulting to the tired white supremacist argument. Believe it or not, there are conservatives who have arguments that don't have to do with bigotry and white supremacy. How shocking. I just outlined to you that the law very clearly goes against affirmative action. Need I say more? Anyway, let's go on to the second counter argument, which is these next two are actually legitimate. Okay, there's this argument that affirmative action is necessary, is one of the only mechanisms that will be effective in rectifying the wrongs of past discrimination. Again, let's go to The View, clip 2.
The Supreme Court has upset a 45-year precedent, ruling it unconstitutional for universities to consider race in admissions. Now, the 14th Amendment is supposed to promise equal protection. But if everyone was actually treated equally, we wouldn't have had to put in affirmative action. See? We wouldn't have had to do it.
Right.
People wouldn't have had to march and begged and gotten hosed and all of these things that people did to just balance us out.
Okay, so Whoopi Goldberg is saying that we need affirmative action to, quote, balance us out. Two things. First, it hasn't balanced us out. I mean, affirmative action has been the precedent of the court, has been allowed in both private and public universities in the United States for 45 years, nearly half a century. If it hasn't balanced us out by now, I don't think it will balance us out if we allow it to go on. That's argument, or my retort to Whoopi Goldberg, my first retort to her. The second one is that there is this argument, I have to say, kind of drives me crazy. Because by the time we get to college admissions, the playing field is already so unequal. Why are we focusing on college admissions and we're not focusing on what goes on in primary schools? There is tons of evidence, a consensus on this, that there is a point at which, I think it's in like 5th grade or 6th grade, so about aged 10 to 11, there is a point at which poor education has a really hard time of being reversed. This problem, which is real, of unequal test scores, unequal, GPAs is between white applicants and minority applicants, that starts way earlier. If we want to balance it out, we've got to make public education better. According to the Nation's report card, their most recent report in May of 2023, only 13% of 8th graders at public schools in the United States meet proficiency standards for U.S. history. That requires explaining themes, events, and people. Only 13%. That is abysmal. Less than 20% of 8th graders in the United States scored at proficiency levels in civics. And in 2022, 8th graders scored 5 points lower in American history compared with 2018. That has been a staggering reversal in the past 5 years. Another report from the Nation's Report Card. This one was back in October of 2022. It looked at federal test results. There was the largest drop in math scores ever in the United States in 2022, and there was a nationwide drop in reading that reversed 30 years of gains. In 2022, the average math scores for 8th graders dropped 8 points from 2019. Reading fell 3 points from 2018 to 2022. I could levy at you so many more just abysmal statistics. Did you know that 75% of Black California boys do not meet state proficiency standards in reading? That is the problem here. I am not saying that college admissions doesn't matter. Of course it matters. But we've got to go back way earlier to fix this issue. I resent when people focus only on when people are applying to college at age 18. The Oregon Department of Education 2 years ago published a memo saying that finding one right answer in math is white supremacy. Objectivity is white supremacy. Why are the people who are getting so angry about affirmative action being overturned, why are they not angry about this stipulation by the Oregon Department of Education? That is close to criminal. And that, more than anything else, more than affirmative action being overturned, is going to disadvantage and not balance out the situation of minority applicants. There are so many other Department of Educations which are pushing these radical gender and racial theories, which are replacing learning hard skills like reading and math. If you look at the largest convention of math teachers in the United States, it has 38,000 public school math teachers in its conference. They had programs this past year on how to undo racism in mathematics. That is what is being taught to public school teachers. The New Jersey Department of Education, the Arizona Department of Education has these crazy stipulations that you have to teach people who are 10 years old that sex and gender is non-binary. That is what is now being taught in the classroom, and we are going away from, as I said, hard skills. At LAUSD, they have replaced learning time in reading, math, and science with Rainbow Club meetings, where students as young as kindergarten, 4 years old, are taught these gender theories, which cuts away from the time that they are spending in other subjects. We have to be focusing on this educational crisis. Overturning affirmative action is not the educational crisis here. And finally, let's go on to the third argument, that minority students without affirmative action will not go to college. Again, for the third and final time, let's go to The View, clip 3.
We live in a society where race has always mattered,
yes,
and continues to matter.
Yes.
So in my view, pretending that it is no longer an issue exacerbates the problem. If you look at a place like California, you had affirmative action dismantled in California in 1998.
Yep.
The very next year, 50% of Blacks and Latinos were no longer in those institutions.
Yeah.
Now, Sunny is right that California actually overturned affirmative action. Can you believe it? California, this liberal state, was one of the first states to do it. Back in 1996, she said 1998, that's wrong. Back in 1996, this was Proposition 209. But she is so wrong about what she said, that Black people were no longer in, quote, these institutions since California outlawed affirmative action. That is a lie. Richard Sander is a law professor at UCLA, and he has dedicated his career to studying the effects of affirmative action. He wrote this great book, I highly recommend it, called Mismatch. He traced the effects of Proposition 209 in California, which overturned affirmative action. Within 6 years of the statute being passed, it was passed in 96, took effect in 97. Within 6 years, the number of Blacks in the University of California system had gone up by 30%. The number receiving bachelor's degrees, went up by 70%. And these numbers were even higher for Hispanic students than they were for Black students. Now, maybe what Sunny is referring to is that in the wake of Proposition 209, there were fewer Black students at the University of California, Berkeley and UCLA, which are the two most prestigious UCs in California. But that doesn't mean that Black students were, quote, no longer at these institutions. They were just at different UC schools. And they were placed in UC schools that maybe were not as elite or prestigious, but they were placed at UC schools that were in accordance with their test scores and with their grades. And also, this had the effect of better integrating other UC schools. How about that, Sunny? I'd love to hear her response to that. Also, the thing that has caused some people to drop out of universities is actually affirmative action. It's not affirmative action being overturned. In 2009, 84% of Black students and 66% of Hispanic students had test scores below their institution's averages. And this had a big effect on the dropout rate. Mismatching has terrible long-term effects for one's academic success. Dr. Thomas Sowell identified this in his book on affirmative action, that in 1987, all of the Black students admitted to University of California, Berkeley under affirmative action, of the Black students admitted to UC Berkeley under affirmative action, more than 70% failed to graduate. The median SAT score for Black students in that entering freshman class was 952. For whites and Asians, and the median scores were 1014 and 1252 respectively, okay? It accords with common sense. If certain applicants are being admitted to schools where they may not be up to the academic caliber of those schools, they are more likely to drop out. How does that help the outcome that all of us want? It doesn't. If Black people are going to be admitted to these schools and drop out, what's the point of affirmative action in the first place? We have to be able to match people well. This is not about not matching people. It's about matching people at the right university. We forget that Harvard isn't the only university in the country. There are many other universities that have just as good, probably if not better, educations than offered at Harvard. Now, that Tom Sowell statistic was from 1987. Richard Sander, who I told you was the law professor at UCLA, along with Professor Steinbuck of University of Arkansas, published very recent data a few weeks ago showing the same thing. They followed 12 cohorts of law students at 4 law schools, so that is over 6,000 students, and they found that a student's degree of mismatch in law school is by far the strongest predictor of whether he or she will pass the bar exam on the first attempt. Students at elite schools, I'm reading here from this study, with LSAT scores 12 to 14 points lower than the median of their fellow students had only a 22% first-time bar passage rates, while students with the same LSAT scores who matriculated to non-elite schools had a 79% first-time bar passage rate. Better matching equals better performance. Plain and simple. I hope that you enjoyed this episode today and that it was certainly more enlightening than some of the misinformation that we have been hearing about affirmative action on the news and in editorials. You can follow me at Julie R. Hartman on Instagram and Twitter, and a reminder to subscribe to this channel. I'll see you all soon. Take care.